a walkout of the court premises. Their reason? The trial judge refused to grant their plea for adjournment. The court had been scheduled to hear the testimony of the prosecution's second witness. On Thursday, the 23rd of October, lead counsel Samuel Atacha notified the court of filing an application of the Supreme Court to prohibit Justice Eugene Nyadu Nyante from further hearing the case, citing bias. He prayed for an adjournment of the case pending the determination of the matter at the Apex Court. But prosecution led by Principal State Attorney Asiedu-Dartey urged that the court dismiss the application. We'll tell you or bring you the thought and position of Atacha, who is lead counsel for the man in question, or the director of the former director of the National Signals Bureau. Before that, let's speak to our court correspondent, Lord Eduasari, who's joined us on phone. Lord, thank you for your time. So tell us exactly why the Atacha-led legal team thought that their position was not being agreed with by the judge. For that reason, they walked out. Why?
Right, Martin. So, Samuel Atacha, today, even before the business of the day could continue, notify the court that there had been new developments in that they had filed an application for prohibition at the Supreme Court. Now, this application is basically meant to prohibit the presiding judge who has been hearing the matter, Justice Eugene Nyadu Nyante, from continuing to hear the case. Now, their reason was that he has been biased towards them since the hearing of the case. Now, after notifying the court about this application, he prayed for, he cited some authorities and indicated that because of the kind of application that he had filed at the Supreme Court, it meant that automatically there should be a stay of proceedings and then an adjournment. But then the Principal State Attorney, or the prosecution led by Principal State Attorney Asiedu-Dartey, rebutted and opposed this submission. He indicated that the mere fact that an application of this matter had been filed at the Supreme Court does not warrant an automatic adjournment. Now, she indicated that this trial particularly is a criminal trial, and the authorities that Lawyer Atacha had cited had to do with another matter altogether, and so they can't be lumped together for this. But Atacha still maintained on that stance. Now, in the end, the presiding judge sided with the prosecution and held that the fact that an application like this is pending at the Supreme Court, it didn't warrant an adjournment in the matter. And so he dismissed that adjournment and then proceeded to call the prosecution's second witness, who is the Director of Finance at the National Signals Bureau, who was supposed to give her evidence in chief. Now, Martin, a bit of background to this. At the last adjourned date, the Director of Finance at the National Signals Bureau submitted some receipts during her evidence in chief. Now, these receipts had to do with the expenditure that Kwabena Adu Boahene, during his tenure as the National Signals Bureau Director, expended, really. So, Atacha objected to that list of transactions or receipts which was going to be tendered, in indication that they were prejudicial, and the fact that it has to do with the National Signals Bureau, it meant that it would affect the security of the country, for which reason he wanted those documents not to be turned into as evidence. And then the prosecution, then led by the Deputy Attorney General, who, by the way, today in court was absent, indicated that it is not in the place of a private citizen to indicate which documentation in court is prejudicial or will affect the security of the nation. That mandate or power lies in the bosom of the executive and, by extension, the government. And then the judge agreed with that. And so that objection was overruled. And then the matter continued. This is one of such instances that Lawyer Atacha has been relying on, indicating that since the case began, there's a term that he likes to use. He says the judge is on an ambulance mode. He just wants the case to be expedited and moved on at the detriment of his clients without them necessarily making the case. And so he went to the Supreme Court to file an application to prohibit the justice or the judge to continue to hear this matter. He spoke to us after this. He was still not pleased about the entire thing. But Martin, even after this was done, because he walked out of the court premises, the accused persons, Kwabena Adu Boahene and his spouse, Angela J. Boateng, they were still in court. And because the matter had been dismissed and then the hearing was continuing, meaning that the second accused was going to continue with the testimony, the judge ordered the accused persons, Kwabena Adu Boahene, to defend him, to call his lawyer back, or meant that you stand on his own as his own lawyer. Now, at that point, the court went on a brief recess, and when they came back, Kwabena Adu Boahene indicated that indeed he hadn't been able to establish contact with his lawyer, and pleaded with the court that he wouldn't be able to, as it were, defend himself or represent himself, and so prayed for leniency and an adjournment, to which the court obliged and the justice or the judge gave the adjournment. And so the case has been adjourned to October 30, Martin, for the continuation of this matter.
Right, Lord. Thank you for that update. Let's now listen to Atachia, who is lawyer for the former Signals Bureau Director, Kwabena Adu Boahene.
In the court since 9 o'clock, as scheduled by the judge, we didn't see the face of the Attorney General. Other cases were being adjourned. We were waiting until all the cases were clear, giving an impression that, look, this case is what matters to the judge the most. Now, yesterday, I filed a motion for prohibition in the Supreme Court, saying that we are not comfortable that this judge will give us justice. I brought it to the attention of the judge. I also raised an issue that we should adjourn the case and abide the outcome of the application to the Supreme Court. The case is just next week in the Supreme Court. The judge is saying no, we won't grant us the adjournment, and that he is ready to continue the case. As to why the judge is in an ambulance route to continue the case and cannot wait for the Supreme Court for 1 week, the list matters to be designed. And I'm caught between the rock and the hard place. How? The ambivalence that you want to disqualify a judge from hearing the case, and you sitting to continue the case. I cannot answer in the Supreme Court, so I need to leave the chamber. Then, I mean, leave him to do what he wants to do best. That's why I've left the court.
Are your client not going to be?
Well, my client is there. I know he can't do any legal work for himself, but they should be glad that the lawyers are saying that they can't continue with the case. They could have also gone out of the court, but they are accused persons, because they agree with me. But because they are accused persons, they can't get out of the court. That's why they are there, because they are accused, but not that they endorse what the judge did.
If you go to the Supreme Court, we are not preempting, and the Supreme Court sends you back to the High Court, how will your approach be?
Well, let's leave it to the Supreme Court. I don't want to play clairvoyance, but I think we have a good case for the Supreme Court to consider. That's what we are doing. We don't know what the Supreme Court will do, and you don't want to play lottery with this very sensitive case.
But counsel, regarding the decision by the judge, he cited two conflicting authorities and decisions by the Supreme Court, for which reason he used his discretion to refuse your application. How does that come to you, seeing that you chose to walk out when really he used discretion?
What discretion is on this matter, in which there is an old authority, the Supreme Court has departed from the authority, and the Supreme Court in 2020 is asserting that when there is a pending application for prohibition, and the lawyer tells the judge looking after the affairs of the case that, look, adjourn the case and let's wait for the Supreme Court to determine the matter. And if the judge should not do that, it implies that the judge is biased. If you see the Supreme Court decision and you don't want to respect it, I can't force him to obey the Supreme Court, which is at the summit of the justice delivery system. But I think we will have a day in the Supreme Court.
Okay.
And so that is Atachia, who is lawyer for the former National Signals Bureau Director there. And the news is that they walked out of court today because they were asking for an adjournment, specifically because they thought that new evidence that had been tendered in was not in favor of the case. that they were defending. And so when the judge declined, they decided to walk out, leaving the suspect alone before the judge. And, the suspect said that he could not defend himself. So the judge asked that he call his lawyer to come in and defend him. He says he's tried several times. He could not reach his lawyer or his legal counsel. So based on that, the judge decided to adjourn the case. So we'll definitely update you as to when the case will be recalled and see how it plays out. This is still 3FM 92.7. You're listening to Hot Edition. And we are going on to our final story just before sports comes in.